Hi, this is Jim Cunningham. What happens in a trust after death or incapacity? Boy, great questions. Enjoy. So, what happens in a trust after death or incapacity? So, we have a living trust, somebody dies, somebody becomes incapacitated. There's this thing called trust administration, right? And trust administration is the process that happens after somebody passes away. And sometimes we end up in probate court, sometimes there's a guardianship or a conservatorship. And we're also dealing sometimes with powers of attorney. So, these are all things that happen. If somebody passes away, then we're looking at probate court. Hopefully we're staying out of probate court, but we're looking at this trust administration. Again, this is where a human a human with a heartbeat has to do stuff. And then if somebody becomes incapacitated, then we're looking at administering the trust, and also using the power of attorney. I do put guardianship and conservatorship there. California, a guardianship is typically for a minor. A guardianship for an adult, we give it a different name. It's called a conservatorship. If you are substantially unable to resist fraud, duress, menace, or undue influence, or substantially unable to provide for your food, clothing, or shelter, you are deemed incapacitated, and that covers finances and healthcare in that order. If you have an elder in your life that maybe or maybe not even an elder, right? Somebody who created this trust and they're trustee and they are not compliant. Sometimes you have to go to conservatorship court to have that, to deal with that, right? So sometimes this non-compliant is an issue. Again, trusts are not self-executing. They require a human with a heartbeat, and they require a person with a beating heart who's not dead to, grab that pen and sign things and produce an ID and have things notarized. And humans do all this stuff. This is not self-executing. This is not a self-executing crypto contract. This whole thing is called trust administration. You can think of trust administration as human beings doing trust stuff that are alive, not and mentally capacitated, right? This just does not happen on its own. So it's not just a set it and forget it type of situation. And remember, every trust has a beneficiary, and it's a mixed bag, right? It's like a mixed nuts, I guess you could say, right? You got some cashews and some peanuts and some filberts in there, but they're all a little bit different. We all call them beneficiaries. They're all nuts a little bit, right? They can be your brothers, your sisters, your friends. They can be complete strangers. And many of these people are married or have life partners, and they have people in their ear suggesting stuff. I don't like what the trustee is doing. So what is a trust administration? A trust administration is like a probate, but without court supervision. Okay, ideally without court supervision. This can be more complex and can be more expensive than a probate. Actually can be, if not enough attention is paid to the living trust during lifetime. So this is the importance of updating and maintaining your trust. And again, the scope of work varies with each trust. So too often professionals fail to grasp all the requirements, right? Lawyers kind of look at their view. CPAs are looking at theirs, and financial advisors look at their view. Sometimes they give bad advice. Okay. And I think too often they're focusing on their core competency, and the things that are kind of in the middle, taxation of IRAs, and, who should the beneficiary be of an IRA? Should it be your living trust? In our firm, we say no, right? It's individuals or an IRA legacy trust. It's just too much to have it flow through the trust. Other lawyers say, well, Jim, it's fine to go through the trust. Yeah, it's fine if all these things line up, the stars are aligned, and everything happens correctly, and the institution is really paying attention and following all the rules, which isn't always the case. But the problem is, if the bases aren't covered, who holds the bag? Who's the one that's held liable? Well, it's the trustee, right? So the trustee is 100% personally liable, is liable for any slip up, no matter how small. The trust assets are not the trustee's personal assets. It's very important to understand. And beneficiaries do get notice under California Probate Code section 16061.7. That is a very specific code section that says within a certain period of time, the trustee must deliver a notice that the person has a right to see a copy of the trust. Now, many times you just send that person a copy of the trust. But a lot of people say, well, I don't want to send a copy of the trust to that person who was disinherited. Well, if it's a child of the decedent, you have to send that notice, right? Otherwise, the trustee is personally liable. What about notice to creditors? Probate has a notice to creditors with a 4-month cutoff date. And this is optional. Sometimes it's warranted. We don't do it a whole lot in many cases, but we do in some. You do have to pay the debts and expenses, and then make distributions. And again, you know, the IRAs, the 401ks, the TSAs, the life insurance, annuities, those all pass outside of the trust, typically to individual beneficiaries, but are included in the overall estate, meaning the executor of the will, the named executor, and many times it's the same person as a trustee, has that duty to file the death tax return. That person has to have the information about the life insurance and the 401ks and the IRAs, because that has to be included in the death tax return. By the way, if somebody dies with owning real property in California, the county assessor must receive certain forms within 60 days of death. By and large, now property is reassessed when a person passes away. Prop 13 goes away thanks to Prop 19, right? So property is reassessed when there's a change in ownership. So if mom and dad bought the property for $100,000 and the assessed value is $200,000, it's worth $2 million. The property taxes were $2,000 a year. Now they're $20,000 a year, right? That change in ownership occurs at death. It doesn't occur when you notify the assessor. It doesn't occur when the property is distributed. Very important to understand that the property is reassessed at its fair market value as of the date of death. And that, of course, they increase 2% yearly under Prop 13. The assessor must be notified within 60 days. Otherwise, there's a 10% penalty on the extra tax, okay? So what happens in the background in the real world is there's this notice that you send to the assessor, because the assessor doesn't know that someone's died, right? They have to be told. Right? They're not paying attention to the Social Security death index and kind of cross-checking, right? They're not doing that. You have to file this form. So the assessor then does an appraisal of the property. What's the fair market value of the property? And then says, hey, tax collector, you know, Mrs. McGillicuddy died, and this $200,000 assessed value, that's really a $2 million property tax bill. So here's $2 million is the value. And then the tax collector goes, okay, well, let me put this in the property tax bill. And then that gets sent out. That whole process takes about 11 months. Okay. So let's look at this example. Tom is a successor trustee of dad's trust. Upon dad's death, Tom notifies the assessor, sells the property, distributes the cash. 8 months later, he gets something in the mail called a supplemental unsecured tax bill, which is the absolute worst property tax bill you can get, because Tom owes that money individually. Okay. As trustee, remember, 100% personal liable. He's got to pay the $10,000. Tom goes back to his brother, Bob, who's a total jerk, and says, hey, Bob, tax bill, $10,000. Can you cough up $5,000? Bob says, get lost. I'm not paying you any money. I talked to my jerk lawyer who says I don't have to give you back any money. And Tom's stuck footing the bill, personally liable. So it's better to know and do a holdback or a reserve, or maybe pay the tax, you know, whatever it might be. But it is better to know this stuff before you just make a distribution. Well, what about probate? The whole point of a living trust, with a properly created and updated living trust centered estate plan, probate can be avoided, but sometimes probate can't be avoided. And people end up in probate court for a variety of reasons. Maybe they buy another piece of property. Maybe they refinance their property, which people aren't really doing now because interest rates are up. Hopefully they don't have to. No name trustee is available to serve. Believe it or not, this does happen. Maybe the trustee says, I'm so done with these people. Ugh, you know, just give me my life back. I'm out of here. Or they don't do it from the beginning. And sometimes there's disagreement about what the terms of the trust mean now. And you may think, well, that doesn't make sense. Well, what if someone writes on their trust? There's disagreement, right? Does this person get the gift or not? Was this an amendment? Was this a revocation? Whatever it happens to be. Or maybe the trust is too short. Maybe it's an 8-page trust and it just doesn't address all the what actually happened in the matter. And the trustee reaches a dead end and says, I don't know what to do because I can't follow the terms of the trust because it's not telling me what to do, right? Failure to locate the trust, a lost trust. This has happened with our clients. You know, we've had a lot of fires in California. That has been a rather, unfortunately, a common occurrence. Probate used to take 16 months before COVID. Now it's about 24 on average. And probate can consume 100% of the value of an estate. Jim, what are you talking about? If it's $1 million asset with a $950,000 mortgage, the probate fees are $50,000. $1 million estate with a $950,000 mortgage is $50,000 in equity. The probate fees are based on the fair market value of the property, not the equity in the property. So I'm not going to go through all the steps of probate, but there are a lot of them. And a lot of the steps of probate are Sequential, meaning you can't do this until you finish that. So some of these run concurrently, but many of them run consecutively, and that can just delay. And this is why people wait years. They say, you know, mom and dad died years ago and we're still in probate. Well, it's because it's an antiquated, slow process. And then you keep COVID on there and you can, you know, add a lot more time. So what about the durable power of attorney? So in our firm, we do two powers of attorney. We do a durable power of attorney for property management and personal affairs, as well as a uniform statutory form power of attorney for a very important reason. What we're talking about here are assets having to do with like IRAs, 401ks, life insurance, and annuities when the person is alive. So imagine somebody, their heart is beating, but their mind is gone. And somebody has to do for this person who can't do for themselves. So the person who is incapacitated appoints an agent, which is also called an attorney. In fact, we do not use that language because it looks too much like attorney at law. It's very confusing, but an agent. So somebody appoints somebody else to act on your behalf. This is agency authority. This is a significantly broader authority than the authority that is granted to a trustee under a trust. And here's why. Because when you grant agency authority, you're letting someone else step into your shoes and assert all of your rights. A trustee is bound by the terms of the trust. So this is one big difference between a power of attorney and a trust, is I think the trust is more defined. This durable power of attorney, unless you limit the powers under the durable power of attorney, these tend to be very broad. And these durable powers of attorney expire at death, again, except for the advanced healthcare directive that says, you know, who can dispose of your remains. But again, it's not the case. A trust goes on after you pass away. So why do we have two powers of attorney? Because we have a longer form attorney drafted power of attorney is probably 30 pages. This is the durable power of attorney for property management and personal affairs. The uniform statutory form power of attorney is a 2-page form, and we add a couple of pages in there for more clarity. But the difference is many times these are not honored by institutions. So this is really important. These are not honored by institutions. And so the uniform statutory form power of attorney says if the institution does not honor the power of attorney, that institution shall pay attorney's fees. So it's a bit of a hammer to get the people to pay attention, because a lot of times, frankly, if these are over about a year old, many institutions ignore the power of attorney. There are 3 phases in trust administration, 3 big phases: inventory, collect all the assets. What do we have? Pay the debts and expenses. Don't forget about reassessment. Someone's got to sign all this stuff under penalty of perjury, and then distribute. And sometimes it's an outright distribution. Here's your check. You know, Johnny, here's your check. Sometimes it goes into an inheritance protection trust, a dole it out trust, special needs trust, or IRA legacy trust. So these are different type of continuing trusts. You can think of it as inheritance. You know, somebody inherits $1 million. It can be in a wrapper, or it can just be, you know, here's your money. If you inherited $1 million, it might go into a joint account with the spouse. And what if there's a divorce? It gets kind of messy. Sometimes it's good to have that money separated out into an inheritance protection trust. And maybe the person who's inheriting can be the trustee of that trust, right? There's some other guardrails in there, but we cover that in many of our other webinars, as well as in the book Savvy Estate Planning. Death of the person who created the trust. It's very important. If the person is married or single, it makes a difference. If the person is married, please pay very attention to what is community property or separate property, marital or separate property, and whether the trust splits into different trusts. Sometimes, you know, this ABC trust, and also the portability return as well. And if a person's not married, it isn't necessarily less complex. It's just typically more complex, believe it or not, when a spouse dies and there's a surviving spouse. So what not to do? I would say the 2 things: if you're married and your spouse passes away, I would not withdraw or roll over any annuities, specifically an annuity, until you speak with your financial advisor, CPA, and your lawyer, because these annuities have very specific rules, and sometimes they're date sensitive, sometimes not. But I would say just the big red flag: I wouldn't touch an annuity. I wouldn't make any decision until you talk to your advisor. And then also don't make any elections with respect to 401ks or IRAs without seeking your advice of your financial advisor and your CPA, because many of those, like once you make an election, you can't undo it. You can't pull the cream out of the coffee on many of these. So what happens when somebody dies? Helen wanted to create a trust and they die, and Daisy is named as successor trustee. Daisy has to follow the terms of the trust as written, the statutes, the case law, the doctrine. What is doctrine? Doctrine is, you know, judges say, well, we see this thread in the law and there are these statutes in these cases, so we're going to come up with a doctrine. So this is not like a statute, and it's not a case. but it is a method of applying the law. And how's Daisy going to know all this stuff, right? She needs to talk to a lawyer, quite frankly, because these are all case specific. So it's very hard to learn the entire body of the law and then say what applies to Daisy. It's a little bit easier to go to a lawyer and say, you know, what applies to Daisy. That person's already learned all this stuff. So the terms of the trust aren't optional, they are mandatory. So some people say, hey, well, if we just agree to do something different, can we do that? I would talk to a lawyer about that, right? That's something, these are mandatory terms. This is certainly not a do-it-yourself or a DIY project. What can a trustee do about assets not held in the trust? So, not much. If somebody dies and the assets aren't in the trust, there's not a lot you can do. You might have to go to court. You might be able to do some other type of actions, but you know, the bottom line is not much. What if you have minor children in there? What if you have loved ones with special needs? What about IRAs and 401ks and annuities? Those pass outside of the trust. Okay. So a trustee really has no authority over the IRA, the 401k, and the annuity. They need that information, but they have no authority over it. And minor children, you know, if a minor child has no parent, then that minor child, you typically ends up with a guardianship. What about a loved one with special needs? What if is that person inheriting money? Will that kick them off their benefits? So many of our clients do set up an IRA legacy trust for minors if they have an IRA or 401k. And they do set up a special needs trust. I mean, I hate to put two heaps on special there, but a special needs trust. That is to receive an IRA, 401k, or annuity. And under the Secure Act and Secure Act 2.0, a loved one with special needs who inherits that IRA typically can stretch that IRA out over their lifetime. We have a whole bunch of material on that in our YouTube page. We do have offices throughout Northern and Southern California. When you call, what should you expect when you call or schedule online? So when you call, your call will be with one of our client specialists, not one of our lawyers. And please do let us know if you want to update or create your estate plan, if you have tax questions, if someone's passed away. Please let us know that, and that kind of gets you to the right person. And tell us your estate planning and tax goals. So what is it that you want to do? Do you have just a simple question, or is this like, hey, I really need help with, my mom passed away and I'm kind of confused, and my jerk brother, whatever it is, just tell them that. But really don't ask for pricing. Only lawyers can quote legal fees, and don't ask for legal advice because only lawyers can give legal advice. So the goal of the call, by the way, is to set an appointment with an attorney. That is fundamentally the point of calling in. You can also go to our website, and I believe you can self-schedule and book a time there. Subscribe to our YouTube channel. If you're watching this, hit subscribe and hit the little bell, and you'll be alerted when we release new content. And we do have our Northern California in-person event coming up March 3rd in Auburn, California. So please, you would want to reach out to us and reserve a time there. And we have a special Valentine's estate planning special, Love and Danger for spouses, widows, and widowers, all things married couples. So that's a one near and dear to my heart. I've been married 31 years, so looking forward to that one.